Someone owes you money. Maybe it's a landlord who never returned your security deposit, a mechanic who charged you for repairs that were never done, a contractor who took your down payment and disappeared, an online seller who shipped you junk and went silent. And every time you think about fighting back, you hear the same thing. A lawyer costs more than what they owe you. Here's what most people never learn. America has a court built exactly for this. It's called Small Claims Court, and it was designed for ordinary people. No lawyer required, simple forms, a filing fee that usually costs less than a tank of gas. And here's the part I love. The people who win in small claims court are not the ones with the most money. They're the ones who show up prepared. In the next 10 minutes, I'll walk you through the entire process, from your first demand letter to collecting your money. Let's unlock your right. Small claims court is often called the people's court, and for good reason. The rules of evidence are relaxed. The forms are short. The judge asks the questions, and the whole hearing usually takes 15 to 30 minutes. Every state has one, and every state sets a dollar limit. In California, an individual can sue for up to $12,500. In Texas, up to $20,000. In New York City, up to $10,000. Most states fall somewhere between $5,000 and $20,000. If you're owed more than your state's limit, you can still use small claims. You just waive the amount above the cap. And honestly, that trade is often worth it to avoid years of regular litigation. And here's something that surprises people. In some states, including California, lawyers are generally not even allowed at the small claims hearing. It's you, the other side, and the judge. The playing field is level by design. Before you file anything, answer 3 questions. 1. Who exactly owes you money, and how much? Not roughly, exactly. Add up the invoices, the payments, the damage. Judges award numbers, not feelings. 2. Can you prove it? A case is a story plus paper, contracts, receipts, texts, emails, photos, bank records. If you have the story but no paper, start gathering it now. 3. Are you still within the deadline? Every claim has a statute of limitations. For most contract and property disputes, it's measured in years, not weeks, and it varies by state and by the kind of claim. But don't sit on your rights. Evidence fades, witnesses move, and businesses close. The best time to act is now. Now, before you touch a court form, send a demand letter. Some states actually require you to ask for the money before you sue. But even where it's optional, it is the smartest first move, because a serious demand letter gets people paid all the time without ever seeing a courtroom. Keep it to 1 page. State the facts, plainly and without insults. State the exact amount you're owed and how you calculated it. Give a firm deadline, usually 10 to 14 days, and close with 1 sentence that changes everything. If I do not receive payment by this date, I will file a claim in small claims court. Send it by certified mail, keep a copy, and keep the receipt. 2 things just happened. First, you gave the other side a genuine chance to settle, which judges love to see. Second, you created Exhibit A. If they ignore you, that letter walks into court with you. No payment? Time to file. 3 details decide whether your case sails or sinks. First, the right courthouse. You generally file in the county where the person or business is located or where the dispute happened. File in the wrong place and you'll be starting over. Second, the defendant's exact legal name. This one is huge. If you're suing a business, that shop called Joe's Auto might legally be J&M Automotive LLC. Search your state's business registry online. It's free. And name the real entity. A judgment against a name that doesn't legally exist can be worthless when you try to collect. Third, the paperwork itself. The claim form is usually 1 or 2 pages. The clerk's office can answer questions, and many courts now let you file online. Filing fees typically run $30 to $100 depending on your state and claim size, and if you can't afford it, ask for a fee waiver. Every state has one. Here is where more small claims cases die than anywhere else. Service of process. The defendant has a constitutional right to know they're being sued, which means the papers must be delivered the way your state requires. And in most states, you cannot do it yourself. You use the sheriff's office, a professional process server, or certified mail through the court clerk, depending on your state's rules. The server then files a proof of service with the court. Get this wrong and nothing else matters. The hearing gets postponed, or your case gets dismissed, and you start over while the clock runs. Ask the clerk which methods your court accepts. Pay the small service fee, and get it done right the first time. You have a court date. Now win it before you walk in. Build a simple evidence kit. The contract or agreement, even if it's just a text thread. Receipts and bank records. Photos with dates. Your demand letter and the certified mail receipt. A 1-page timeline of what happened, in order, because judges process timelines faster than speeches. Bring 3 copies of everything. 1 for you, 1 for the judge, 1 for the other side. If a witness saw the work, the damage, or the promise, bring them, or bring a short signed statement if your court allows it. Then practice telling the whole story in 2 minutes, not 5. 2. Facts, dates, amount. The person who rambles loses the judge. The person who is brief and organized sounds like the truth. On the day. Arrive early, dress simply and neatly, and check in with the clerk. When your case is called, the judge runs the show. Answer what's asked, hand up your exhibits when invited, and never interrupt the other side, no matter what they say. Your calm is evidence too. 2 things to expect. First, many courts offer mediation right there in the hallway, and a settlement you shape can beat a judgment you wait for. Second, the other side might file a counterclaim, saying you owe them. Don't panic. It gets heard the same day, on the same facts, and your evidence kit answers it. Most judges won't rule on the spot. The decision usually arrives by mail within a few weeks. You won. Congratulations. Now, the honest part nobody tells you. A judgment is a piece of paper, not a check. The court does not collect it for you. Many people and most businesses simply pay because the judgment is now public record and it follows them. But if they don't, the law hands you real tools. You can garnish wages. You can levy a bank account. You can place a lien on property so they can't sell or refinance without paying you. And if you don't know where their money is, you can ask the court to order them to a debtor's examination, where they must answer under oath. Judgments also last a long time, often 10 years or more, and in many states they can be renewed, collecting interest the entire time. Be patient and persistent. The paper is powerful. Your 7-step path, start to finish. Step 1, know your case. The exact amount, the proof, the deadline. Step 2, send a demand letter by certified mail. Step 3, file in the right county against the right legal name. Step 4, serve the papers properly, by the book. Step 5, build your evidence kit and a 1-page timeline. Step 6, show up early, stay calm, let the judge lead. And Step 7, collect. Garnish, levy, lien, and don't give up. If a landlord kept your deposit, this is exactly the court where that fight ends. And my security deposit video pairs perfectly with this one. Facing something bigger, like an eviction notice? That step-by-step guide is on the channel too. Subscribe to unlock your rights, because knowing the law shouldn't require a law degree. And remember, the court was built for you. Use it.